Judge, I don't know what he believes Ms. Hartzog would lend to this case. And the problem with the matter that I think is becoming more and more apparent to the court is none of this has to do with the case. All of this has to do with his position and perceptions about me personally and as a lawyer. And as the hearing goes on, you'll get more flavor of that, I'm sure. But you've seen essentially what his position is. He wants to call me a liar. He wants to say I'm a liar. He wants to present documents, including a document in which I say I have not lied. That's his evidence. I told him I had not lied. And beyond that, he wants to quibble about whether there is an oral statement to Ms. Hartzog or a written statement to Ms. Hartzog, but nothing really about the case. And as I've said to Your Honor, there's no value that Ms. Hartzog would lend to the case because essentially he's not entitled to any motion that he's filed as a matter of law. It is clearly on its face a frivolous action and matter. And I would say that's another reason not to drag Ms. Hartzog into the middle, but she has counsel and they can decide that issue. I'm here to stand by everything that I've said in emails, everything I've said to anybody about the case, everything I've said to Mr. Grodner in any way. But I don't think that there is any value in bringing Judge Brady into the case by a subpoena initially. He didn't even show up for the date that he subpoenaed them, and then over the weekend when nobody would know, he issues one of his emails that he withdraws the subpoenas. So we all show up that morning. He doesn't even come. He does go to the clerk's office and file his withdrawal that very morning, but he doesn't even come into the courtroom where the people that he subpoenaed, where we're having the hearing that he caused. He doesn't even come here. And we engage in that kind of business in his case at his whim when he does these things. And Ms. Hartzog is the latest victim of his activities and conduct. I'm still here willing to respond to any of the claims that he has made with regard to the matter, openly, candidly, with no problems. But I don't, unless he can give some foreshadowing of what he believes his evidence with Ms. Hartzog is going to yield to this court on a Rule 59 motion that is without authority. And Judge, as I said, I provided the cases. He has them. Davis v. Rizzo says it very clearly and concisely. And the second case, Tetra Tech Tesoro, says it clearly and concisely. And that one is even in the context of a summary judgment kind of motion. So he really, I want him to say what he wants to say about me, and I want him to have all the time he wants to do that. And whatever the court wants to indulge with that is fine with me. I'm here to do that. But all the collateral damage that he is doing by his conduct, I hope we will address in the other motions that I have filed, and that there is no basis for Ms. Hartzog to have to endure this.